So the time has now run out and the DOJ will have to give an answer on what they plan to do with the nationwide vacatur and block of the ATF pistol brace rule. And recently they decided to drop a Biden administration charge against a brace pistol, which gives a greater insight into what they actually plan to do. Now, I want to wish you all a happy Easter. I hope you enjoyed this time with your family, but also I hope you appreciate the true purpose behind this weekend, why a lot of us are celebrating. I hope you guys go to church and all that. I'm not going to preach to you guys, but this is an amazing weekend for a lot of us, and I hope you enjoyed this weekend with your family. And also, if you guys want to support the channel for free, please consider subscribing. That helps to, grow the channel, get this out to more people, and then just drop a positive comment down below, because that also helps to tell the algorithm that you appreciate this type of 2A content and it should share it to more people. Now, as I mentioned in the intro, we have some very important news in the battle against the ATF and their current restrictions on brace pistols, as treating them as SBRs. That is a holdover policy from the Biden administration through their brace rule. And currently we are waiting for the Trump administration to give their current policy on how they plan to address brace pistols and what they plan to do in this lawsuit going forward, but also what they plan to do with that holdover rule that was put in place by the Biden administration. Currently, there is a nationwide vacatur on the pistol brace rule and multiple preliminary injunctions, which are protecting various 2A organizations and their memberships. However, now with the new administration in power in the recent Trump executive order on protecting Second Amendment rights, the Fifth Circuit Court of Appeals decided to hold the Mock versus Garland case temporarily. The Trump administration notified the Fifth Circuit that they wanted to hold the case, they wanted to review the case until they determined what they internally wanted to do when it came to this issue of braced pistols. The Fifth Circuit granted the 30-day abeyance, but it was set to automatically dissolve on Monday, April 14th, and that's exactly what happened. On Monday, April 14th, it automatically dissolved, and that means that the ATF, the AG's office, now needs to notify the Fifth Circuit on what they plan to do with braced pistols. Now, at the same time, we received some very interesting news this last week. We were notified that the DOJ decided to drop a Biden administration charge, which was brought against an individual who had a CZ Scorpion with a pistol brace attached. The prior administration was trying to charge him with illegally possessing an SBR in violation of the pistol brace rule, but now that charge has been dropped. So a lot is shifting right now, and the approach on braced pistols as SBRs is currently changing. The DOJ decided to drop those charges, and now they need to tell the Fifth Circuit on what they plan to do with this nationwide vacatur case, and maybe what they plan to do with the brace rule at large. Are they going to try to get rid of it, or are they going to try to defend it in some of these lawsuits? Now, you may recall that the ATF recently suffered a lot of losses in a variety of cases when it came to pistol braces. Not only did they have multiple preliminary injunctions granted against them, against that rule, but recently Judge O'Connor in a federal district court in Texas issued a final merits decision, which was in the Mock lawsuit, and that struck down the rule completely nationwide. Now, in that decision, Judge O'Connor stated that at the conclusion of the majority's careful analysis, they held that the final rule is properly characterized as a legislative rule. And it is relatively straightforward that the final rule was not a logical outgrowth from the proposed rule. Therefore, the final rule must be set aside as unlawful or otherwise remanded for appropriate remediation. Now, one of the primary analysis points that came out of that decision was that Judge O'Connor believed that the final rule in regards to pistol braces was a violation of the APA because it did not align with the logical outgrowth test. Essentially, the big problem with the final rule when it came to pistol braces was that the proposed rule that was put in place by the Biden administration, that had a worksheet called the Worksheet 4999, and it had a point system where you would look at your braced pistol and you would check the boxes and add points based on the characteristics that your brace pistol had. And if you got a certain amount of points, well, then it was classified as an SBR. So in the proposed rule, there was a worksheet, but when it came to the final rule, they scrapped all of that and they went to some more subjective standards and kind of gave carte blanche to the ATF to decide, anything could be actually an SBR, not just a braced pistol. So here, Judge O'Connor said that failed the logical outgrowth test. It was not in alignment with the APA, and that's why he struck it down nationwide. Currently, all the briefs have been submitted to the Fifth Circuit, in this mock case, and currently we are waiting for oral arguments to take place. However, the Trump administration, once they got control of this case, decided that they wanted to hold it in abeyance for 30 days so they could decide what their plan would be when it came to braced pistols. There was also some issues at the end of the Biden administration's last, term, when they were still trying to say that the ATF could enforce these restrictions on braced pistols purely under the statutory text. However, that was put aside. The Trump administration has taken a temporary delay in this case to decide what their position is, but now time has run out. The abeyance has automatically dissolved, and the ATF, the AG's office, primarily the AG's office and the DOJ, needs to decide how they're going to proceed forward in this case. And they're going to need to give a notice to the Fifth Circuit on what they plan to do with braced pistols. Now, one good sign for this case is the fact that recently the DOJ decided to drop charges against an individual who was charged with illegally possessing an SBR in Washington, D.C. Now, in a recent motion, the DOJ stated that the United States, by and through its attorney, the United States Attorney for the District of Columbia, respectively moves to dismiss count 1 of the superseding indictment without prejudice. So the government is moving to dismiss count 1 in the interest of justice. So this is a good sign that the DOJ decided to drop the short-barreled rifle charge for possessing a CZ Scorpion equipped with a pistol brace, and that came in the US versus Taranto case. Recently, we've also received multiple statements from the AG's office through the chief of staff that they will be changing positions in a variety of cases, the Peterson suppressor challenge and other challenges. Her office has even now stated that they will be investigating localities in states like California for delaying issuing CCW permits, and all of those are good signs. Of course, it's no guarantee that they're going to do the right thing in the pistol brace case. We also saw her recently establish the Second Amendment Task Force, which is focused on two-way strategies in developing plans to address some of these cases, like the brace pistol cases. One important thing to note is that the current abeyance does not impact the nationwide vacatur decision that was issued by Judge O'Connor, and that will remain in place until the Fifth Circuit rules in this case on the final merits, or essentially until the Trump administration decides to act on the rule, maybe revise it or rescind it on their own. Of course, if the Trump administration decides to proceed forward in the pistol brace case, that would tell us everything we need to know, that maybe they're not as pro 2A. But it's a good sign that all the noise that was made about the Taranto case and the whole pistol brace charges that ended up getting dropped by the DOJ, it's a good sign that the AG's office is listening to what we're telling her to do. And I think that that is probably going to lead to the same development in the pistol brace case and mock, that they're going to say, hey, we've changed policy. We're going to rescind this rule. We do not believe that brace pistols are SBRs. Now, I will say one of the things that seems to be happening right now in the AG's office is that she is struggling to get all of these lawsuits in check and get all the underling attorneys to follow Pro 2A directives. We saw recently in the US versus Morgan case where you still had some DOJ attorneys under this Trump administration arguing that the Second Amendment restrictions under the NFA are valid, that they could in fact restrict machine guns because they're not in common use for lawful purposes and therefore not protected arms under the Second Amendment. I don't think that's something that the administration wanted to be argued coming out of them, but is one of those things where you had an attorney in an office in one of these lawsuits maybe going rogue or just not having good enough oversight in submitting these type of arguments that look bad for the Trump administration. So maybe one of the things that she's doing when it comes to this case is keeping a closer eye on what some of these lower level attorneys are doing and what they're arguing to ensure that it actually aligns with the Trump 2A policies. But regardless, now the abeyance has automatically dissolved and the DOJ will need to respond and give an answer on how they plan to address this mock lawsuit and what they plan to do with pistol braces going forward. However, I think the writing is really on the wall because ultimately they decided to drop the charges against brace pistols in the Taranto case. So if they're refusing to enforce the rule, then I doubt they're going to be willing to openly defend the rule in a lawsuit. So I think that gave us a clear sign about where the ATF and where the DOJ and the AG's office is really heading when it comes to brace pistols. So as we get more information, as this develops more and unravels, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.